Namaskar. I, CA Deepak Chopra, Chairman Direct Tax Committee of KSCA, welcome you all to yet another webinar under series KSCA Shorts. As the name suggests, these webinars are short and to the point. To deal with today's topic on PMLA provisions, we have with us Advocate Shri Amar Gahlot. Sir, on behalf of entire team KSCA and all the attendees, a hearty welcome to you, sir. A
Thank you
quick
so much.
brief introduction of the speaker for the day. Shri Amar Gahlot is an experienced legal professional consulting in the areas of economic offences and taxation, including money laundering, income tax, GST, Benami, foreign exchange, and other incidental laws. Being an ex-engineer turned bureaucrat, Sir brings on board a diverse industry experience as well as legal knowledge. He has practiced in diverse areas like economic offences, taxation, corporate advisory, etc. He has practiced before various courts and tribunals, including before the Supreme Court of India. With this very brief introduction, I once again welcome you to the session, sir.
Thank you so much, sir.
Before I hand over the proceedings to the speaker, a small announcement on the upcoming programs. KSCA is organizing a residential leadership program at Vivid Earth Resorts, Bandipur. The program will assist in enhancing leadership abilities in the lap of Mother Nature. For more details, log on to ksca.com and register now as very few seats now remain. Over to you, sir.
Thank you so much, sir. And Deepak, sir, I expect that the screen would be visible and my voice is audible.
It is, sir, very much, sir.
Okay, wonderful, sir. And it's a slightly awkward thing because I'm speaking, it appears like speaking to the mirror because I cannot see anyone. but yeah, that's the format of webinars these days. And to all the learned participants, a very good evening. And I'm really honored and thankful to Karnataka State Chartered Accountants Association to have given me this privilege of maybe spending some time, half an hour, 45 minutes, on sharing my thoughts on the provisions of Money Laundering Act as they may apply to the CA fraternity and the profession. And of course, the trigger, as I can sense, and I'm also receiving a lot of queries and doubts being raised. The trigger has been the recent notifications on 3rd of May and 9th of May that have been issued by the central government under the Prevention of Money Laundering Act. However, as the topic suggests, I with due permission from all of you, would like to use this opportunity to briefly understand little more set of things, and hence this is a broad outline for the next half an hour, sirs, that I seek to cover. First of all, to cover the PMLA provisions, because I understand some of us may not be on a daily basis or on a periodic or regular basis be dealing with the Prevention of Money Laundering Act, that's PMLA. So we'll spend a few minutes in understanding what is the offense of money laundering, what is the concept of a scheduled offense, and how money laundering is a derivative offense. And then come to the legal provision concerning something that applies to chartered accountants, advisors, other experts also, that is aiding and abetting or assisting the offense of money laundering, which is what is often invoked by the enforcing agencies to really raise allegations against us. The second part is some analysis of the two notifications that have come on 3rd and 9th of May respectively, to understand what is the intent and purpose behind the notifications, to do a simple bare read of the notifications quickly, to understand the intent and purpose, to look at how these two notifications that have come, they are slightly different in their manner of drafting and the deeming fictions created compared to the earlier notifications in way back in 2015 that they came, then followed with the consequences of being designated as a reporting entity. And a larger question that I am asking to myself for the past 2 weeks, that whether any chartered accountant who maybe does any of the activities that have been notified, whether he or she becomes a reporting entity with respect to all the other activities that they otherwise perform, like audit or maybe giving out accounting opinions, etc. And then we come at the last part of the presentation to cover and identify some noteworthy issues. A recent Supreme Court decision that has come on the same date, on 3rd of May itself, in the case of Deloitte, wherein a very precedentiary Bombay High Court decision has been overruled by the Supreme Court, and prosecution has been upheld against the auditors. We'll quickly touch upon the concept of attorney-client privilege and how the manner of mandates being given and taken by chartered accountants and lawyers and clients, how there's a difference in attorney-client privilege and the protection that arises. And lastly, what happens to the fees that we take, whether it can be treated as proceeds of crime, because the larger theme is money laundering. So I'll quickly start with the first part, that's the relevant PMLA provisions. Sirs and ma'ams, what I often say it is that money laundering is a derivative offense. That means that the enforcement directorate, and so far we know that it's the enforcement agency for the Prevention of Money Laundering Act. The enforcement directorate is the enforcement agency for only 3 laws. One is the Foreign Exchange Management Act, second is Prevention of Money Laundering Act, and third is a more recent law, that is the Fugitive Economic Offenders Act 2018. But that's a nondescript law, not yet seen the light of the day. But so FEMA and PMLA are the two broad or often enforced laws by the enforcement directorate. Let us say enforcement directorate sees a cognizable offense, some offense, some crime, some wrongdoing happening. Can they really start an investigation on their own? The answer is no, because that offense would be anyways covered by what we commonly call as the law of the land, the Indian Penal Code, or some other law that is enforced. So let's say there is a kidnapping, that's the crime for the purpose of discussion. So we already have the state police, which takes care of ensuring that the kidnapping does not happen. God forbid if it happens, then in that case, the offender should be brought to book and he should be punished. So the police is already doing that job. Now, what is the offense of money laundering, and can the ED step by itself? The answer is no. The ED will have to wait for the police to take some action, and once the police has taken some action, let us identify this taking of action by registering as equivalent to registering an FIR. So once the FIR has been registered by the state police, and there is money involved in the kidnapping. I took kidnapping as an example because it's often done with the motive of maybe generating cash or generating some proceeds of crime. There is money involved in such crime, then the ED can certainly step in if there is money laundering also being done. So that means that there is a crime, and that crime has resulted in something that's called proceeds of crime, and those proceeds of crime have been laundered or attempted to be laundered. So the enforcement directorate can only inquire or investigate in this offense of money laundering, which is the latter part, that is the laundering, and we'll see what laundering means. We'll just quickly read the definition once. Once the money or the proceeds of crime have been laundered, only that part of the investigation can the enforcement directorate investigate. The police investigates the main offense, the consequential or derivative aspect of the offense, that is how is money rotated, concealed, disposed, layered and integrated into the larger so-called white scheme of things. That part only is what concerns with the offense of money laundering, and hence consequentially the enforcement directorate. So money laundering hence is a derivative offense unless you have some main crime, and technically we call that as a predicate offense in the language of PMLA, or not in the informal language of PMLA, because under PMLA we have something that's called the scheduled offense. The predicate offense having been done, committed, I'm repeating this because it's a very fundamental concept, sirs and ma'ams. Once the predicate offense or the predicate crime is done, which is the corresponding agency is the police or the other law enforcement agency, that has resulted in proceeds of crime. The proceeds of crime have been laundered. So this secondary or lateral or consequential or derivative aspect is what Enforcement Directorate and investigates under the Prevention of Money Laundering Act. Let's quickly look at the bullet points, sirs, here, that what are the various things that comprise or constitute the offense of laundering. So we have concealing or disguising the true nature, using proceeds of crime to acquire, hold, own, possess, or use property, investing them, transferring them, or disposing the proceeds of crime, or maybe indirectly using the proceeds of crime to further fund criminal activity. So it's a very wide definition, and broadly anyone who, so there may be one set of offenses or crimes where there is no money involved at all. So in that case, of course, one can rule out the possibility or of application of PMLA, but the moment money gets involved and results or arises out of the conduct of a crime, we can think that PMLA can be applied. However, not every crime or offense under the sun, under the Indian Penal Code or the Customs Act or the Income Tax Act or the Black Money Act, not every offense will be has been correspondingly listed out under the Prevention of Money Laundering Act. So let us say there are 10,000 different types of offenses across the various laws that are applicable or in force in India today. Let us say on 18th of May 2023, there are 10,000 such offenses. The Prevention of Money Laundering Act says that out of these, let me figure out only the serious 100 ones, because the remaining 9,900, even if there are monies involved there, even if there are monies being laundered there, the state police or the income tax department or maybe the EOW, they are adept and they are capable enough to punish the wrongdoer there. But for the more serious 100 offenses, if there is money involved, if there is laundering involved, let Enforcement Directorate jump in. And in these 100 serious offenses, we'll take strict action under Prevention of Money Laundering Act. So these 100 offenses are, sir, what's shown in the second part of the slide, which are termed as scheduled offenses. So as the name suggests or the term suggests, these 100 odd, I'm saying 100 is not a precise number, it's only for the sake of example. This set of offenses called scheduled offenses are provided in a list in a schedule to the Prevention of Money Laundering Act. The more serious ones resulting in money or proceeds of crime which have been laundered and hence amenable to PMLA applicability. I'll straight away come to this slide, sirs and ma'ams, because the title for the day is Applicability to Chartered Accountants. More often than not, we see that a professional would not be involved per se in the very act of maybe doing that offense or maybe conspiring to do a criminal offense, etc. But we find ourselves getting stuck in aiding and abetting and assisting. Strangely, unlike, for example, Indian Penal Code, where we have a different scheme under sections 108, 109, 110, where aiding and abetting are treated and punished differently compared to the actual crime. For example, the Indian Penal Code will say that murder is defined under section 300 of IPC. The murderer is punishable under 302, but attempt and abetting the commission of a murder, these are different offenses. They are not punished with the same intensity and vigor as as the law, the judicial or the justice system will punish a murderer. But in certain cases, we see that the abetting or assisting or attempts of any crime are punished with with equal or equivalent vigor or intensity as the actual commission of the offense. This is one such example, because Section 3, the last slide we saw, Section 3 of PMLA defines what is the offense of money laundering, and Section 3 not just defines the offense of money laundering and thereafter Section 4 punishes it. We see that the offense of money laundering and the assisting and abetting of the same is also defined and punished and provided for in a same and similar manner. That means the same punishment, that is 3 to 7 years, that is to be meted out to the actual person who's committing the scheduled offense and resulting in money laundering. The same punishment entails to a chartered accountant or a professional or any other person who is merely assisting and abetting the offense of money laundering. So that adds some seriousness to the issue. Now, let us keep this aspect in mind. Towards the third part of our presentation, we'll look at what all this entails. Let us now touch upon the second aspect, that is the recent notifications that have been issued on 3rd of May and 9th of May. And a little background, sirs and ma'ams, that when the Money Laundering Act was enacted in 2002, if we all remember, it was quickly in the aftermath of 9/11, the US attacks. And immediately after that, the Financial Action Task Force was constituted at a global level. And they mandated that every country which wants to have any economic relationships with the developed economies, typically and specifically the US, they should put in place some law that really combats or counters money laundering and combating of terrorist financing. So initially in 2002, the Money Laundering Act was enacted to adhere and comply with the international mandate. However, the rules, etc., were notified only in 2005. That's when truly the act became operational. And since 2005, we have seen the act not look southwards at all. It's only looking upwards because the scope of the act is expanding. One of such expansions in scope happened somewhere in 2013-14 by way of an Amendment Act 2012 that was passed. And from 2014-15 then, a concept of a reporting entity was added. That yes, now we have constituted the PML, we have enacted the PMLA way back 10 years back. We have constituted the Enforcement Directorate. We have done a cadre restructuring of Enforcement Directorate in 2012-13, given it a large number of officers and staff. But we do not have enough information on our own, which we can use to identify independent money laundering instances. So they brought in certain amendments, let us call them as the reporting entity set of amendments, where they added some very, very, I would not say very serious, but very expansive and comprehensive reporting obligations on certain entities or certain verticals. Banking, financial institutions, and intermediaries were one of them. Intermediaries, for example, stockbrokers. These sets of businesses or types of businesses like banks, etc., were already providing information to let's say income tax department, and we all know the annual information returns under 285BA that all of these entities have to anyways pass on and file with the income tax department. So they were already providing information to one or the other government departments, but there were further reporting requirements added to these specific sectors. And so, and there was a, beyond this banking, financial institutions and intermediaries, the central government kept, as usual, the central government kept a reserve for itself, where it said that we can notify any other industry vertical, any other profession, any other activity, etc., as and when we like. The consequence of all of this was that banks, financial institutions, intermediaries besides providing and supplying information to the tax departments, to the RBI, and to various other, let's say the IRDA, a stockbroker has to provide information to the to the SEBI, insurance brokers to IRDA. So besides that, there were some reporting requirements added. The enforcement directorate could, probe into this set of information that is being maintained by the reporting entity. And if not provided, this non-compliance could result in some monetary penalties against the reporting entities. So, and for the time being, it continues to be a monetary penalty that the reporting entity, if it does not comply with the mandate of the ED, does not maintain or provide information, does not carry out certain other responsibilities, then you'll be monetarily penalized. So in that larger set of reporting entities is where the recent notifications add chartered accountants, company secretaries, and cost and works accountants. Third May notification says that the financial transactions, and please focus on the bold words, the financial transactions carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities. And then there is a set of 5 activities listed out: buying and selling of any immovable property, managing of client money, management of bank, etc., organization of contributions, and creating, operating, and managing companies, LLPs, trusts, or buying or selling of business entities. So the framework is this. There is a list of 5 activities that a chartered accountant or a company secretary or a CWA may carry out. And if he is carrying those activities out on behalf of the client, then in that case, such financial transactions will be covered within the scope. The notification says, interestingly, that these activities, and towards the second last line on the slide, says, shall be an activity for the purposes of the said subsection. First of all, it is not a subsection, it's a subclause. 21SA6 is the subclause. So there's an error in the notification here. It should read subclause. 2.1 is the subsection. An activity for the purposes of said subsection means that there should have been a definition of activity. There is none. So subsection 2.1 does not contain a definition of activity, but from a fair reading and from a purposive interpretation, it figures out that they want to bring this within the scope of 2.1 SA6. The consequence of this notification is that with respect to these activities, a chartered accountant becomes a person carrying on designated business, and consequently it becomes a reporting entity. Let us look at the second notification, sirs and ma'ams. Over here, it is not mentioning specifically the professions of CA or CS or CWAs, but very similar 5 more list of activities. There is some overlap in the last notification and here, because within 6 days, I'm told that within 6 days between 3rd and 9th of May, the central government realized that it is not just the CA, CS, and CWA community or fraternity or profession which are really doing this. There are a set of large other professions and businesses and persons who are also rendering or delivering these services, which they now list out. Formation of companies, directorship services or secretarial services, then providing registered offices, business address or accommodation for a company, acting as a trustee of an express trust, etc., and acting as a nominee shareholder. And I'm reminded of these investigative journalist association. It's called the ICIJ, I think, International Consortium of Investigative Journalists, which unearthed the Panama Papers and a lot of these alleged scams. And a lot of companies out there in Singapore, etc., for example, would provide a lot of these services where you can simply sign a form and you can incorporate a company. You can choose to have directors provided by the service provider. You can choose to have shareholders provided by the service provider, etc. And just 1 second. And I'm told that recently a lot of other people in India taking inspiration from these very successful business models which flourish in other countries. They have also started providing these services, and that's maybe the reason why in the second notification the scope has not been restricted only to CAs, CWAs and company secretaries. A collective reading. Deepak sir, I think some participant is raising the hand.
You can proceed, sir.
Okay, sir.
We'll take the questions towards the end is what we had.
Okay, sir. So, of course, the second notification has some exclusions and we can quickly skip them. Just one or two of them are relevant. For example, exclusion number C. Very obvious Section 7(1)(b) declarations that we give out, that everything that's being filed for the purpose of registering a company is in compliance with the Act. So there are certain exclusions, so they have been considered. Collectively looking at things, here is where we come. Financial transactions in relation to certain activities, and on the right hand side we have the list of 10 activities carried out by a CS, CS or CWA on behalf of his client in the course of his profession shall be an activity for Section 2(1) of PMLA. So this is the overall syllabus or overall scope, that if the conditions on the left hand side are satisfied, then the activities that are listed on the right hand side, any of the 10 activities, they will result in a person or a professional becoming a reporting entity. The intent and purpose is clear. I would want to point out very quickly, sirs and ma'ams, about the manner of drafting in this and take you back. Look at this slide. They are saying that if you're doing this on behalf of the client and there's a list of 5 activities, then the financial transactions shall be an activity for the purpose of said subsection. All the earlier notifications under sections 2(1) SA6 would not say like this. They will say all the earlier notifications. For example, they said that real estate agents are also in 2015-16. And they under the same subsection, they issued notifications saying that real estate agents will be covered. What is the language that they used to use? They used to say 2(1) SA6, 2(1) SA is the definition of person carrying on designated business. And then reporting entity definition says that a person carrying on designated business shall be a reporting entity. So they used to say, all the earlier notifications used to say that anyone who's a real estate agent is a person carrying on designated business. This is what the central government is notifying. Anyone who's an insurance broker will be a person carrying on designated business. This is what the central government is notifying. In this, what they have done, however, a chartered accountant may be carrying on 50 activities, including audit, advisory, this and that. Out of that, they are saying only 5 activities shall be an activity for the purpose of subsection. So there's a very clear difference. Brings us to this question. And we'll see the consequences of being designated as a reporting entity in a very quickly. Just look at the last question towards the last on the slide, sirs and ma'ams. Let us say out of the 10 different activities, including advisory, including issuing accounting opinions, including carrying out statutory external audits, a chartered accountant also, let us say, acts for a client under a power of attorney and sells his immovable property. So it's only one activity that he does amongst the multifarious other activities that he otherwise in the course of her or his profession he carries out. So the way, and let's look at the slide, the remaining slide now, consequences of being designated as a reporting entity. There is a spate of consequences. You are required to maintain the records in a particular format and manner. you are required to carry out some due diligence of the clients that you accept or accept the engagement of. You are required to respond to the notices. So reporting entities have certain responsibilities and obligations and duties that they are supposed to meet under the PMLA. Nowhere in that set of sections or obligations or responsibility is it mentioned that reporting entity only vis-a-vis such and such activity. So once, because of some reason, a person becomes a reporting entity, the question arises, for this entire set of activities, is he or she required to maintain records, carry out due diligence, etc.? So I may be, for the power of attorney client who comes to me and I sell the property acting on his behalf, I'm all right if I am required only to maintain his records, carry out the due diligence, etc. But here I am conducting an audit for another company in my regular course of audit. Over there also, if you require me to maintain records, etc., would be just too much. But the law so far, sirs and ma'ams, in my reading is not very clear, because they have listed out certain activities. All of that notification results in the CA or CS or CWA becoming a reporting entity, and then the reporting entity requirements or the prevention or the maintenance of records rules, nowhere do they filter out or categorize reporting or obligations based on activities. It's linked to a person as a whole. Coming to the very last part of what now merging the two things. So the mandate given to me was very quickly summarize or cover PMLA provisions applicable to chartered accountants. First part, we saw that irrespective of these reporting entity wala part, first part is that irrespective of these notifications, in the last few years, we've been seeing that a lot of money laundering allegations are being raised and a lot of accusations are being leveled, and we are seeing consultants face a very difficult time at times, without taking names or raising any specifics here. But we see that these 4 bullet points are very common. They say that in case of frauds, corporate frauds, money laundering, conspiracies, etc., the consultant has aided or abetted the fraud. And if you recall in the second slide, we looked at section 3, where the consequences of aiding, abetting, assisting are the same as oneself doing or committing the offense of money laundering. They say we have facilitated the money laundering process through placement, relaying, integration by becoming a part of the chain, or even simply giving advisory on that basis on which the client has acted, or maybe ignoring or conducting a wrong audit, maybe passing through wrongful statements. The Companies Act also, for example, would say that if you do not report, it casts responsibility on the auditor that you ought to report frauds. So wrong financial statements, wrong audit, suppression of facts here and there, the communication not being proper. So that's one set. We have a recent decision of Supreme Court on 3rd of May, incidentally the same date, where linked to the earlier slide, where all of these allegations are being raised against consultants who may have acted in an advisory capacity, may have handheld a little bit, but Bombay High Court, in its earlier decision in the same case, had said that maintainability of prosecution against auditors is not there, because one of the reasons, or what turned out in the court in the decision, was that they have resigned earlier, etc. But larger theme was, or the feeling and sentiment was, that auditors act in an advisory capacity. So sort of, unless there are some very incriminating evidences resulting in a money trail, wrongful benefits, etc., you please keep this community separate. The Supreme Court, Justice Amar has recently overruled this on the same date, saying that no, the basis on which the High Court has said that and given a clean sheet and quashed the proceedings against auditors, not maintainable, it's not acceptable, and prosecution should be continued. And so linked, these two slides are linked, what the Supreme Court is now saying and what the agencies are now have been historically saying, typically for the past 4 or 5 years. Coming to the last part, that what happens And what's the protection available? This is a distinguishing feature between advocates and chartered accountants. Under sections 126 to 129 of the Evidence Act, the advocate community or fraternity is given the privilege wherein any communication, be it linked to litigation or not, if it is concerning a matter on which the client has come to you to seek legal advice or to litigate a particular matter, the advocate and the client communications are privileged and they cannot be accepted as evidence in any court of law or before any person who is authorized to accept or take evidence. That protection manifests itself into a practical result wherein such questions or allegations are not generally raised against advocates unless there are hardcore evidences of involvement of the particular professional in some wrongdoing. A question often I am asked is that in case a mandate or engagement is done between an advocate and a chartered accountant and not between the chartered accountant and the client directly, is that also covered by attorney-client privilege? Of course, it is covered by attorney-client privilege, subject to 126 to 129 of Evidence Act. It should not appear that all the communications are directly happening between the client and the chartered accountant, but and only for the sake of showing it as such, the engagement has been structured in this manner, and all of you would be well aware of the form and substance doctrine, so that applies there also. Whether fees taken by, one last point is this, that under PMLA and the prevailing jurisprudence, whether the fees that's taken, let's say a person comes to me, I'm a chartered accountant, a person comes to me and asks for an accounting opinion, I give the accounting opinion, take fees. Towards 2016, 17, 18, a lot of chartered accountants were questioned because the fees that was charged ultimately was treated or alleged as proceeds of crime. But we today have Bombay High Court and Delhi High Court very clear decisions saying that no, it's a clear quid pro quo between provisioning of service, and a chartered accountant or an advocate is not supposed to drill deep down into the source of funds which have been used to compensate him or remunerate him with respect to the work performed. So with that, Deepak sir, I end this, and quickly to summarize that I have done my job. That part number one, non-notification general applicability of PMLA with respect to aiding, assisting, abetting, what are the consequences of the same on the profession of chartered accountants. And second part is very quickly touching upon the recent 2 notifications, the set of 10 activities, and seeing some legal points over there. Thank you so much, sirs and ma'ams.
Thank you very much for this insightful discussion. Now, before we come to the Q&A, if you can very broadly give a macro overview of what reporting obligations do I carry as a reporting entity now?
Sir, so we have broadly these set of sections. 11A was introduced subsequently. So as a reporting entity, sir, broadly the obligations are, I would say, classifiable into 1. There are 3 broad buckets, if I may. It's not structured like this in the statute, but broadly, things to be kept in mind while onboarding clients. That is the due diligence part. Second is maintenance of records. And third is the reporting as and when asked. And I'll quickly, half a minute each on each of these 3 points. First part being, what should I keep in mind while onboarding clients? So 11A would say, is a section would say that you need to carry out some diligence of your client. For example, if it's a company, you need to identify who's the beneficial owner of the company. The section 11A would say that in case of banks, because bank is also a reporting entity, in case of banks, they can use online Aadhaar, etc. But in case of, for us as chartered accountants, maybe passport can be used or maybe offline Aadhaar can be used. And there is a sequence of some other things that are mentioned there, which have to be used to ensure that we are not dealing with a person who has shady antecedents. So first part is what to be kept in mind as while onboarding is the client. Let's call it that as due diligence. Second part is, sir, maintenance of records. And sections would say that, but there is a detailed set of rules prescribed under the Prevention of Money Laundering, Maintenance of Record Rules 2005. And over there you have even KYC is also covered there, but the bulk part or majority part of that is what are the different records that are to be maintained and in what format and manner. So that's the second part regarding maintenance of records, and these records have to be maintained for 5 years. And the third part, sir, is reporting that, okay, we are maintaining the records, we have onboarded the client after due diligence. As and when, and we are asked, we are sent a notice by the ED, we have to comply with that notice. Earlier, we could have taken a plea of maybe the file not being there. For example, if like for us advocates also, clients would say, I'm taking the file away to another lawyer. And so he takes the file and the file is gone. Someone asks me, I can simply say that I do not have the file anymore because the case has been transferred. Maybe in certain cases earlier it was possible, now it is not. So the third thing is reporting. As and when asked, because I am supposed to maintain the records, I have to report, comply with such requests or instructions from the Enforcement Directorate, failing which there is a penalty of a monetary penalty only of up to 1 lakh rupees. And that's where it stops for every non-compliance. So that's the broad 3-pronged responsibility of a reporting entity, sir.
There are a bunch of questions on the Q&A box. With the permission,
Yes,
can I
sir.
check them also? We may not have time for all of the questions, but a couple of them at least, if I have a permission.
Yes, sir.
Whether receipt of money through bank account from a client towards payment of his advance tax by SCA, is this covered under PMLA regulations?
Sir, I would say that because if we look at this is a second list of activities. So managing client money, securities and assets, right? So I would want to read it in this manner that yes, it is covered, sir. So I'm assuming that the question is that the CA is receiving the client money and paying on behalf of the client to the tax department.
Yes.
So it will be covered, sir.
It will be covered. So I have to follow all the KYC norms and documentation, record maintenance, all of it.
Yes,
Whether
yes,
mere
sir.
entering into Hawala transaction attracts PMLA?
No, sir. So I would say, for example, it's a very strong statement, but I often support it and assert it that Hawala transaction, if I'm saying that I'm giving money in cash to someone in Mumbai and the person is giving me cash in New Delhi after half an hour or 2 hours or whatever, apart from tax, I think there is not much illegality that is attracted. So there may be the underlying reason of entering into the Hawala transaction, sir, would really govern the answer to your question. As I said, merely transferring cash, genuine business proceeds from Mumbai to New Delhi through so-called Hawala route, there is no illegality in that. And income tax laws also maybe support a lot of things where cash transactions are permitted if it is in the exigency or so. So, however, if the Hawala transaction, the underlying transaction is connected with some illegality, then sir, it would attract PMLA.
So as long as it is not proceed of crime and it is
Yes.
business proceed, Hawala is not covered under PMLA.
As long as it is not proceeds of crime, and proceeds of crime meaning that it should have arisen directly or indirectly from some scheduled offense or crime.
The next question is interesting. So
Yes,
my
sir.
client has earned money by way of proceeds of crime, and it has been informed to me that the money is borrowed from some other person. And now, as a chartered accountant, I have assisted him in buying an immovable property. Whether I am liable or covered under the PMLA provisions.
So just when I'm reading it now, so the client earned money by way of crime and informs to us that the money borrowed from another person and CA suggested to buy a mobile property. No, sir. So if we look at this slide, sir, it says that, first of all, the transaction should have been carried out by the chartered accountant on behalf of his client. Here, I am reading into the word suggested that you have used in your question. So if the chartered accountant has only merely advised that you may buy and even issued a written accounting opinion or advisory opinion, I think this entire set of notifications, both of them will not apply to us. But yes, if the money gets routed, for example, this first part also, buying and selling of immovable property, it means that that the CA has bought or sold immovable property on behalf of the client. So there has to be a power of attorney, and the actual person on the job negotiating and doing entering into agreements is the CA himself. But in your question, if the question is restricted only to advisory being given by the chartered accountant, he'll not be. However, in this question, if the chartered accountant has himself received a power of attorney and bought the property under his own signature as a constituted attorney, then in that case, he will have to comply with the notification, sir.
Right, sir. As part of the KYC procedure, what documents should I precisely collect from my clients?
Okay, you got Niranjana ji ka jo question. Okay. Sir, you have to look up depending on different types of transactions. As I said, under section 11A, sir, primarily read with the maintenance of record rules, because maintenance of record rules also contains some KYC, and it's a long list of documents there. My request is that you please go through that list of there is a part and schedule towards the end of that maintenance of record rules, which lists out KYC documents. So kindly go through, sir, 11A section and the maintenance of record rules 2005. They contain a detailed list of KYC documents that you ought to maintain.
Next question: if the client buys securities on the basis of advice of chartered accountant, will this be considered as management of securities and therefore covered?
Absolutely not, sir. Absolutely. So if it's only an advice, unless the CA is himself, I'm repeating myself, that is carrying out and executing that transaction, advice will not be covered here, sir.
CA has assisted the client in only obtaining a lower deduction certificate for the buying of immovable property. Is this covered under PMLA?
Absolutely not, sir. And these are all my opinions, sir. I'm saying very assertively, but please pardon me if I make a mistake. But it does not appear so. In my opinion, absolutely not.
My client does some illegal activity through cash, but it is nowhere accounted in the books of accounts. So what is my exposure under PMLA?
No, he's saying as an auditor, what is my liability? Or
as an auditor, what is my exposure? What is my liability?
there is absolutely no liability, sir, under the Companies Act or the Income Tax Act or under PMLA. I think if, let us say, the person is a mere trader, I'm taking an example. Let's say my client, I'm a chartered accountant, my client is a trader. If I read what is the practice of accountancy and what all things can be done under the Chartered Accountants Act 1949, if I look at the responsibilities of an auditor under the Companies Act, very cautious of 143 and 145 of Companies Act. I look at what my responsibilities are under the Income Tax Act. I would say my client, a trader, let us say, who keeps half of his turnover in the books, half of his turnover outside the books, and let us say he has some other illegality also, which is a hardwired crime, which is a third set of proceeds for him. I am told as an auditor only the first part, that is the on books or within the books turnover that he is doing. Unless those books make a suggestion to me that there are other two sources of income also existing, there is no liability that I have as an auditor, sir.
So you've said this in your presentation, but if you could reaffirm conclusively as to should the KYC and other obligations be discharged only with regards to those 5 set of activities or with regards to all my clients going forward? So should I take a KYC for all my clients or only for the 5 set of activities?
I'm still stuck on this, but I think we are also writing a representation to the central government and to the director Saab. And I think they will issue a clarification. As on date, there is no clarity on this, that should we take a KYC even with respect to other activities. Legally, if you ask me, sir, on a very, very literal reading and interpretation of the way they have issued out the notification, wherein 5 activities are resulting, indulging in any of the 5 activities is resulting in me becoming a reporting entity, and me becoming a reporting entity is requiring me for all my conduct as a person, as an entity, to maintain records and be carrying out some due diligence, etc. So literal reading would suggest this, or a literal interpretation under law would suggest this. A purposive interpretation, sir, on the other hand, where let us look at the substance and the rationality behind these notifications, it would suggest otherwise. So literal interpretation, take KYC for everything. Purposive interpretation, take KYC only with respect to any of the 5 activities that are listed there. But I think they will issue a clarification soon on this.
So until then, conservatively, all client onboarding should first begin with KYC now.
Conservative view, yes, sir. On the date, yes.
Right, sir. We have several more questions, but I think we are running out of time now. Before we formally conclude today's session, we have a small announcement to make, and we have a president, Pramod Srihari, sir, with us. Sir,
Yes,
over to you, sir.
Yeah, good evening, participants, and good evening also to the speaker. Then elicit a very
Good evening.
Good evening. It was a wonderful presentation. One of the most happening topic for everyone. Everyone is more than exciting. Everybody is worried as to where they are stand. And I hope this presentation has clarified quite a amount of doubts. The number of questions itself is the witness as to how much people are really worried on this circular. Having said that, sir, I just want to say a program of KSCAA, which is happening on 26th, 27th, and 28th, which is on growth mindset. This is a program which is for the chartered accountants, which wherein where we are talking about what it means to have a growth mindset. While functional expertise is very important to many of us, but that itself hasn't taken for us to grow. There is something which is more beyond. We spent a good amount of time. There are case studies. You'll be able to network, and it is in Bandipur, in a resort, a residential place, and there'll be quite an exciting events which is lined up, encouraging as to why you should grow, what is grow, and what it means to have a growth mindset. It's an exciting event. I am expecting that a good number of participants from this also will turn up for this event of KSCAA on growth mindset. This is all what I wanted to announce. I will leave Deepak to take the further on this program.
Thank you, sir. I now take this opportunity to formally thank our speaker for the day. Sir, the entire team KSCAA is extremely grateful to you for your insightful and crisp deliberation on the topic. Thank you, sir. Thank you for having consented to our program and having spared your precious time in enlightening us. Thank you, attendees, for attending in such large numbers and making this webinar a success. The session stands concluded formally.
Thank you so much, sir. Thank you, sir.
Thank you, sir.